In the name of Allah, the Beneficent, the Merciful, I bear witness that there is no God but Allah, and I bear witness that Muhammad is his messenger. Peace be unto you, our listening audience. And welcome back once again to Cairo, Know Your Rights University. Today, we wish to share with you how sometimes public officers engage in conduct which violates their oath to the Constitution and oftentimes end up violating our private right. What do we mean when we say this? Public officers sometimes engage in conduct that is in direct conflict with the duties they owe the public in general. It has long been agreed that public office officials occupy positions of public trust. The Constitution confers limited authority on each branch of the federal government. It vests Congress with enumerated legislative powers in Article 1, Section 1 of the Constitution. It confers upon the President the executive powers in Article 2, Section 1, Clause 1. And it endows the federal courts with the judicial power of the United States. Article 3, Section 1. In order to remain faithful to this tripartite structure, the power of the federal judiciary may not be permitted to intrude upon the powers given to the other branches, and vice versa. It's called separation of powers. Although the Constitution does not fully explain what is meant by the judicial power of the United States, it does specify that this power extends only to cases and controversies in Article 3, Section 2. And no principle is more fundamental to the judiciary's proper role in our system of government than the constitutional limitation of federal court jurisdiction to actual cases or controversies. Standing to sue is a doctrine rooted in the traditional understanding of a case or controversy. The doctrine developed in our case law to ensure that federal courts do not exceed their authority as it has been traditionally understood. The doctrine limits the category of litigants empowered to maintain a lawsuit in federal court to seek redress for a legal wrong. That's from Valley Forge Christian College versus American United for Separation of Church and State, Incorporated. Supreme Court case. In this way, the law of Article 3 standing serves to prevent the judicial process from being used to usurp the powers of the political branches and confines the federal courts to a properly judicial role. Cases have established that the irreducible constitutional minimum of standing consists of three elements. The plaintiff must have 1. Suffered an injury in fact, 2. That is fairly traceable to the challenged conduct of the defendant, and 3. That is likely to be redressed by a favorable judicial decision. A public office is a public trust, and the holder thereof cannot use it directly or indirectly for personal profit. And officers are not permitted to place themselves in a position in which personal interests may come in conflict with the duty which they owe to the public. The failure of a public officer to perform a public duty can constitute an individual wrong only when some person can show that in the public duty was involved also a duty to himself as an individual. and that he has suffered a special or a peculiar injury by reason of its non-performance. James Lucietto versus James Kingen, Illinois Appellate Court, 1969. In the case of Hills versus Bridgeview Little League Association, it was said, to sustain a cause of action for negligence, the plaintiff must establish the existence of a duty owed by the defendant to the plaintiff, a breach of that duty, and an injury to plaintiff proximately caused by the breach. Now, before we continue, we wish to stress that our basic and fundamental God-given private rights are supposed to be protected by the Supreme Court from encroachment by the government. It seems to be that when we are drawn into the lower courts, who seem to be operating on a secret jurisdiction which only the prosecutor and the judge are privy to, this secret jurisdiction is said to be a colorable admiralty jurisdiction based on the condition of contract. The judge and the courts call it a statutory jurisdiction. But it is also true that it is said that the statutes apply only to public officers, especially when the office itself is created by a statute. Now, we are not saying that we are accepting the benefits of the statute, but what we are saying is that public officials' violation of their oath to the Constitution as well as their violation of statute makes them liable in damages to private individuals if such violations cause injury to private individuals. Usually, when a public officer violates our God-given, unalienable rights, it has in some way, shape, or form have to do with the corruption of that office by means of the public officer having an interest in some corporation coming against you, or he may have received a bribe or a kickback from some corporation. Therefore, he makes a judgment against you or votes against you, your best interest to fulfill his obligation to some corporation or private interest. Let us quote a document called The Depth of Corruption in Illinois, Anti-Corruption Report Number 2 from May 13, 2009. Public corruption in Illinois has a long history dating from the first scandal involving Chicago aldermen and Cook County commissioners in the late 1860s. At that time, they participated in a crooked contract to paint City Hall. Today, nearly a century and a half later, crooked contracts still cost the taxpayers millions of dollars a year, and crooked politicians still go to jail. As we continue our study of public corruption, we have discovered that our original findings underestimated the level of corruption in recent years. We now know that more than 1,500 individuals have been convicted of myriad forms of public corruption since 1970. Based upon the testimony before the Illinois Reform Commission and our own research, we now believe that that the cost of corruption or corruption tax for the city, for the Chicago and Illinois taxpayer, is at least $500 million a year. This is based upon testimony before the commission that about 5% of state government contracts are given out to political cronies and campaign contributors, and on our own tallies of the costs of the major scandals over the last 4 decades. In our last report, we provided a detailed analysis of the 30 aldermen and former aldermen convicted of public corruption since 1970. In this report, we describe some of the major scandals of the last 4 decades, a timeline of more than 375 convicted individuals at all levels of government, and a further analysis of some of the costs of corruption which have caused us to revise our estimate of the corruption tax. The details of these scandals and their costs are included in the appendices of this report. Our research on all aspects of corruption is continuing, but we provide this update to support the report of the Illinois Reform Commission and to contribute to the ongoing debate in the state legislature. Only comprehensive reforms can lessen the level of corruption in Chicago and Illinois, currently the capitals of corruption in the United States. A public office is a public trust. Borough councilmen, as fiduciaries and trustees of the public interest, must serve that interest with the highest fidelity. The law tolerates no mingling of self-interest. It demands exclusive loyalty. The theory is that a public officer assumes the same fiduciary relationship towards the citizens of his community as a trustee bear to his cestui trust or beneficiary. They have the right to expect that in everything that appertains to their business or welfare, he will exercise his best judgment, unaffected and undiluted by anything which might inure to his own interests as an individual. Now let's point out one of the statutes that state legislatures passed to prohibit public officers from using their position to engage in self-dealing transactions. Section 3A, Public Officer Prohibited Activities Act states, no person holding any office, either by election or appointment under the laws or constitution of this state, Illinois, may be in any manner interested either directly or indirectly in his own name or in the name of any person, association, trust, or corporation in any contract or the performance of any work in the making or letting of which such officer may be called upon to act or vote. No such officer may represent, either as agent or otherwise, any person, association, trust, or corporation with respect to any application or bid for any contract or work in regard to which such officer may be called upon to vote. Nor may any such officer take or receive, or offer to take or receive, either directly or indirectly, any money or other thing of value as a gift or bribe or means of influencing his vote or action in his official capacity or character. Any contract made and procured in violation hereof is void. The legislative intent in enacting these statutes was to codify sweeping prohibitions against public officials and officers engaging in conduct which divides their loyalty between their personal interests and their fiduciary duties. The statute is unique because only public officials can violate its provisions. These officials are held in public trust and owe a fiduciary duty to the people they represent. The high standard of conduct demanded of public officers, coupled with the broad sweeping language of the statute, permits no other interpretation as to its intent and meaning. Elements of breach of fiduciary duty. Under Illinois law, upon which this theory is based, recovery for a breach of fiduciary duty requires proof of three elements. 1. A fiduciary duty exists. 2, that the fiduciary duty was breached, and 3, that such breach proximately caused the injury of which the plaintiff complains. The term proximate cause describes two distinct requirements: cause in fact and legal cause. Lee versus Chicago Transit Authority. Cause in fact exists where there is a reasonable certainty that a defendant's acts cause the injury or damage. A defendant's conduct is a cause in fact of the plaintiff's injury only if that conduct is a material element and a substantial factor in bringing about the injury. A defendant's conduct is a material element and a substantial factor in bringing about the injury. A defendant's conduct is a material element and a substantial factor in bringing about an injury if, absent that conduct, the injury would not have occurred. Legal cause, by contrast, is essentially a question of foreseeability. The relevant inquiry here is whether the inquiry is of the type that a reasonable person would see as a likely result of his or her conduct. Now, we would like to ask a question. If an administrator or a judge violates any of our constitutionally protected rights, such as right to due process, right to equal protection, right to contract, right to privacy, etc., due to his violation of the conflict of interest statutes, would this give an individual a private right of action for damages for the judge's breach of fiduciary duty in violating this statute? Does such conduct by a judge violate any of the Illinois Supreme Court rules, such as Canon 1, Rule 1.1, a judge shall uphold and promote the independence, integrity, and impartiality of the judiciary and shall avoid impropriety and the appearance of impropriety in all of the judge's activities? Canon 1, Rule 1.2. Rule 1.2, promoting confidence or trust in the judiciary. A judge shall act at all times in a manner that promotes public confidence or trust in the independence, integrity, and impartiality of the judiciary and shall avoid impropriety and the appearance of impropriety. Or Canon 3, Rule 3.15. A judge shall conduct the judge's personal and extrajudicial activities to minimize the risk of conflict with the obligations of judicial office. Let us know in the comments. We thank you once again for tuning in. Until next time, peace and blessings to you all. Know Your Rights University.